Friends, my opinion is being sought by my younger professionals, advocates, chartered accountants, and by various companies whether the interplay of judgments of Supreme Court in Safari retreats and Bharti Airtel service tax matter and Delhi High Court in Bharti Airtel regarding telecommunication turnover will lead to claim of input tax credit in contravention of 17(5)(c) and D as invalid. Now, this is a huge question because Supreme Court in Chief Commissioner GST versus Safari Retreat laid down a law in the pre-amendment of 17(5)(d), that is plant or machinery was the phrase used at that time, which is subsequently changed to plant and machinery. They said that if building was being made for renting and earning rent and paying GST, then input tax credit should be available, and they upheld Odisha High Court. The Safari judgment, when we read as a whole, it's a very lengthy judgment, we all know. The basic question before Supreme Court was that is there any difference between plant and machinery and plant or machinery? Plant and machinery has certain exclusions in the explanation appended to section 17 that also excludes telecommunication turnovers. Supreme Court went on a premise that something has to be immovable to invoke 17(5)(c) that deals with specifically first contract service, and 17(5)(d) deals with immovable property. Both have roots in section 2119 definition of works contract. Now, on Safari Retreat, hundreds of articles have been written, and most of us have debated in various lectures in our PPTs. But today's question is, Safari Retreat judgment went on a premise that 17(5)(c) and D used two phrases, plant and machinery, plant or machinery, and Supreme Court interpreted plant or machinery, and government by way of subsequent amendment through a finance bill retrospectively amended plant or with plant and. Does it make any difference? That is the question. In view of the latest Madras Bar judgment of Supreme Court, I will question the very basis of this amendment simply to nullify a judgment without any valid and justified constitutional reasons. Will it negate the ratio of Supreme Court judgment? Time will come where this legal proposition shall be tested by people in various high courts and Supreme Court. Then came the judgment of Bharti Airtel, Delhi, where the revenue contended that telecommunication turnover are specifically excluded from the definition of plant or machinery by way of explanation appended to section 17 and also for the purpose of chapter 6 of GST Act. Delhi High Court did not favor that contention. Delhi High Court says that something had to be immovable in order to invoke such a provision. So the cornerstone of legal proposition in view of the Delhi High Court judgment was whether the telecommunication towers could be held to be immovable, and for holding something to be immovable, there are 5-6 tests laid down by Supreme Court in various judgments which are mentioned on page 15, 16, 17 of Delhi High Court judgment of Bharti Airtel, which is it should be immovable and it should have been erected for permanent use, and it should be attached to earth, and if it has to be taken out, it should not be damaged, and it should be, they should have an intention to create this as immovable. When Delhi High Court tested this telecommunication towers, where the petitioners' counsels said the telecommunication tower cannot be held to be immovable, in view of judgment of Bharti Airtel in service tax matter of Bombay High Court, where SLP were dismissed by Supreme Court without keeping a question of law open, and in view of Vodafone case of mobile towers. But the revenue insisted that there is an exclusion telecommunication turnovers. Delhi High Court fine-tuned the legal interpretation. They say exclusion is if telecommunication tower was immovable. In view of the judgments of Supreme Court, Bharti Airtel service tax matter, Vodafone case, Delhi High Court came to conclusion that telecommunication towers, though they are built on a concrete base, the concrete base is immovable, no doubt about it. It is attached to earth and it is permanent in nature. It is intention to make it immovable. But telecommunication towers that were made to stand on those bases were constructed based on nut bolt theory, and by opening the nuts, those could be detached and taken it anywhere else. Now, in Supreme Court in Safari Retreat also laid down a functionality test, whether something which is being built, notwithstanding movable or otherwise, can we say that this was necessary for the very functioning of the work of the taxpayer? On this, the remand case is still pending. But functional test, and Delhi High Court also adopted the marketing test. It is very clear that if I am making something which does not qualify to be immovable, or a works contract service for 17.5C, or immovable for the purpose of 17.5D, I should be entitled to input tax credit and I shall claim. For example, in my factory, either as a contractor or as an owner, I make 30 aluminum cables as temporary offices for functioning of the factory. I make silos, I make sheds, I make temporary labor colony where I put waterproof tents based on nut bolt, and I create a labor colony. I even create a kitchen in the shed. I even create a temporary entertainment space. Can we say these are immovable when tested on the cornerstone of attached to earth, permanency, intention to create immovable, and I cannot take away without damaging the basic thing? All these things I can simply, I can take out the nut and screws and take anywhere and use it somewhere else. I can even hire them. And there are people who make, look at the way films are made. All temporary sets are created. Though they are standing on the earth, they are not standing on the earth, attached to earth, with an intention to make them permanent. Therefore, friends, the interplay of Bharti Airtel and Safari Retreat with Supreme Court Vodafone mobile towers and Supreme Court in Bharti Airtel service tax matter, my take will be and is that we shall take input tax credit as long as we are not in 17.5C. 17.5D, depending on the factual matrix that you confront of a client, do take input tax credit. Don't shy away from taking risk. Lawyers must take risk. You must form an opinion, because if you do not take input tax credit today, then 16.4 limitation shall hit you. You cannot take. Therefore, depending on facts of the case, in more than 99% case, I shall claim input tax credit if I'm not making the building under 17.5C exclusively for my own use. In all other cases, I shall take a risk, have the guts and form an opinion to claim input tax credit. Now, what are you going to lose if you take input tax credit? Supposing a 17.4 notice comes to you, or a 74A notice comes to you after 1/4/25. So what is the legal proposition? By that time, much water would have flown on the issues we are raising in this video. You can take a call whether you want to reverse the input tax credit. The only cost is interest. Penalty may not be leviable because you are reversing based on an opinion immediately, even before show cause notice. So therefore, only cost is interest, but the revenue, the taxpayer has earned a lot of income by way of ROI on the input tax retained and not deposited. Therefore, take a risk. In my view, the Bharti Airtel cements the original ratio of Safari Retreat before amendment in 17.5D. God bless you.